Welcome to EU Privacy for All, Session 6 on GDPR, on liability, Article 77. A key recital in GDPR is recital 118 because it stresses the key pillars regarding liability. First, the brand new provision in GDPR is the fact that a damage which a person may suffer should be compensated not only by the controller but also by the processor. The concept of damage is also broadly defined. The notion of liability focuses and is based on a right that is given to the data subject, the one of receiving full and effective compensation. Additionally, each controller or processor should be held liable for the entire damage, even if compensation may be apportioned according to the responsibility of each controller or processor. Finally, a controller or a processor who would have paid full compensation may institute recourse proceedings against the others, whether they are controllers or processors, and they were involved in the same processing. The negotiations regarding liability pointed out two facts. Both European Parliament and EU Council agreed on the fact that there should be a damage recognized whenever it's non-pecuniary, this is the European Parliament wording, or immaterial, this is a wording retained by EU Council, and on the fact that controllers and processors should be liable, but the wording and the framing was different. On EU Parliament side, controllers and processors shall be jointly and severally liable. On the Council side, a processor shall be liable for the damage caused by the processing only where it has not complied with obligations of this regulation specifically directed to processors, or the processor acted outside or contrary to lawful instructions of the controller. Article 77 on the right to compensation and liability in the GDPR finally retains a wording proposed by EU Council. Any person who has suffered material or immaterial damage as a result of an infringement of the regulation shall have the right to receive compensation from the controller or processor. The logic retained is also the one of the Council, because basically the controller is liable for the damage caused. However, a processor shall be liable only where it has not complied with obligations of these regulations specifically directed to processors or acted outside or contrary to lawful instructions of the controller. Exemption from liability is possible if a controller or a processor proves that it has not in any way been responsible for the event giving rise to the damage. Moreover, where more than one controller or processor or a controller and a processor are involved, each controller or processor shall be held liable for the entire damage. This is done so that data subjects would be ensured to receive effective compensation. Finally, where a controller or processor paid full compensation, it is entitled to claim back from the other controllers or processors involved that part of compensation corresponding to their part of responsibility. Recital 60 and 62 bring additional information. The first one focuses on the fact that the controller remains liable at the forefront. He is the one that should establish appropriate and effective measures whenever a processing is carried out by himself or on his behalf. Recital 62 requires a clear attribution of the responsibilities. including where a controller determines the purposes and means of the processing jointly with other controllers, or where a processing operation is carried out on behalf of a controller. Currently, the directive lays down in Recital 55 and Article 23 4 key points to bear in mind. First, compensation is central, and it is based on a damage. Second, this damage is not defined as being immaterial. GDPR is really explicit on this point. Third, only the controller could be held liable. And fourth, he might have exemption if proving that the fault is on the part of the data subject or force majeure, mainly. What should accountable data controllers and processors get prepared for? First, a broad definition of damage. It is either material or immaterial. Second, being held liable for the entire damage, because the idea behind that is that the data subject would be paid full compensation. Being ready to claim back against other controllers or processors involved in the processing. Laying down contractual provisions on exemption and recourse proceedings. The Recital 63A is interesting here because it reminds us on the fact that the controller should use only processors providing sufficient guarantees. This is something that is also laid down in Article 26. However, it makes somehow clear that the controller still is responsible for being sure that processors will provide the guarantees needed on the security side, but also on reliability and technical and organizational measures. So, the court's upcoming decisions might bring more clarity to this sharing of responsibility between controllers and processors.